Welcome to the EFC webinar on religious freedom. My name is Karen Stiller and I'm an editor with Faith Today magazine. Today we're joined by Bruce Clemenger, president of the Evangelical Fellowship of Canada. The EFC is acting as an intervener in a case with the Ktunaxa Nation in British Columbia. Today we're going to look at why we care about the religious freedom of other religions and how the religious freedom of other religions impacts our own. I'd like to encourage you as participants in this webinar to send in your questions at any time using the chat function at the side of your screen, and we will try to deal with every question that comes our way. This is a great opportunity to just learn together and share information, so please take advantage of that. So let's begin. Bruce, can you first give us an overview of this particular case and why it matters? You'll need to unmute yourself, Bruce, sorry. And we'll just, little technical glitch, people, but we'll get that figured out. Are we on now, Bruce? Good. Perfect. Okay. Yes. So just an overview of the case, and so people know what we're talking about.
The Ktunaxa Nation, there are really 6 tribes, and their ancestral lands are in the Kootenay area of BC. So if you think of Banff, and kind of a bit west and south, all the way down into Washington State and Montana. So that's their ancestral lands. And many years ago, back in the late 80s, a corporation started to apply to the BC government to establish really a ski resort. Quite a sophisticated, some of the plans included up to a 1,000-bed facility for guests. And that would obviously involve permanent year-round staffing facilities as well. And over the years, the nation grappled with this because they understood that there would be some economic benefits, some jobs from having this ski lodge built. But increasingly over time, they began realizing that this would really infringe on their religious freedom, to the degree that they, in their beliefs, they believe that the spirit of the Great Bear resides in those valleys, in those that mountain range, and they felt that a permanent residence would likely chase away or scare away the spirit of the Great Bear, which they don't worship the spirit of the Great Bear, but they commune with the spirit, and this would infringe upon their religious freedom, their religious expression. Now, they weren't opposed to people using the area, using the mountains, using the valleys, hiking, skiing, whatever the case may be, or camping even. It was the idea of a permanent residence. So on that basis, they then challenged the government's decision to allow the ski resort to be built. And they complained on both under Section 2A of the Charter, which deals with freedom of conscience and religion, and Section 35, which deals with Indigenous peoples' land claims.
Okay, and right away, I feel like evangelicals across Canada would ask the question, why do we care about this case? And that the spirit of the Great Bear part sounds unusual to our ears. So help unpack for us that, please.
Yeah, and I think the spirit of the Great Bear and the whole idea of sacred land was probably strange to the ears of the government as well, which is probably part of the reason why we're ending up in the Supreme Court. Kind of behind it all, when I first came aware of the case, the first question being asked the Supreme Court was whether when the government's intending an action, or a quasi-government agency is intending an action that a group of people thinks is going to violate their religious freedom guarantees in the Charter, must the government respond to them? And the first thing to know about this case is that while the nation did express concerns about their religious freedom, the government ignored that altogether. They focused on the land claims issue in Section 35, but they completely ignored the issue of religious freedom. So the first question this case raises is that if a group of citizens are concerned that a government action is going to infringe on their religious freedom, and they raise that issue with the government, must the government at least address their concerns? In this case, the government did not. Another thing that has surfaced as the case went through the courts is does Section 2A only protect people's religious freedom if no one else is impacted by the decision. The Court of Appeal kind of implied that since this religious freedom claim about protected land and about use of land would affect other people's use of the land, that maybe Section 2A doesn't apply. So the question is, does Section 2A apply in that situation? And then thirdly, the land is something that the nation uses to pursue or to exercise their faith. And so our means or vehicles or things that people use in facilitating their faith, are they covered by Section 2A as well? So this is again, an interesting case, because as evangelicals, we really don't have anything that's in a sense equivalent.
Okay.
As evangelicals, we have sanctuaries in our churches, but quite often those sanctuaries are multi-use facilities. And our churches themselves look more like community centers than they do like traditional churches. Others within the Christian tradition have more of a honed-in theology on like a sacred place, an altar, chalice, a kind of a worship space. But then you really have to go outside Christianity really for the idea of kind of sacred lands. So you get a lot of the conversation again when you look at Israel. You get issues like Mecca, Medina, the Temple Mount for Jews and for Muslims. So there in other religions outside Christianity, you have more of a sense of land, that there's a kind of a sacredness or specialness about land. But it's a little foreign for evangelicals. But why we engaged, and I should say that we're joined in this intervention with the Christian Legal Fellowship, which is an association of Christian lawyers. When we look at this case, we realize that there are several key issues that are being raised in the Supreme Court that deal with religious freedom. How the court responds in this case will set a precedent for how it understands religious freedom in other cases. So we need to be there to back the indigenous nation in terms of asking these questions of the court, and hoping the court will give more clarity about what we understand religious freedom to mean, and how that religious freedom will be understood and adjudicated and balanced by various levels of government and the courts.
Okay, go ahead, Bruce. Sorry.
Please finish now.
Okay, thank you. Were the First Nations groups surprised that the EFC would back them with this, or how did they respond to your intervention, to our intervention?
They're welcoming our intervention. Actually, there's a number of groups that are intervening, a number of faith groups, some local churches from the area are intervening, and other groups as well. So there's, I think, a lot of religious entities in Canada saw this it could be a precedent-setting case, and we're very concerned about it. As well, I think part of it is religious freedom in Canada has usually focused on the individual expression, individual rights to have the freedom to worship, to believe what you will, and to practice those beliefs in a public way. Rarely has it gone to the area of things like sacred places, the means you need to conduct your religious expression. So for us, it might be churches or Christian educational institutions that are necessary for us to work out our faith in the area of education or in worship. But when you move into the area of land, it's kind of unique. It's something that's not, again, it's not something we experience regularly kind of within a Christian tradition, but certainly other traditions. So if the charter is supposed to protect religious freedom of all people, then the courts and government need to get their mind around what religious freedom means in these various contexts and these various traditions.
Can you just briefly explain what Section 2A is for participants who may not be as familiar with it?
Sure. The Charter of Rights and Freedoms is set out. Section 2 begins the list of the freedoms that are guaranteed, and then the rest of the Charter moves into rights. And so of the core freedoms are freedom of conscience, religion. They're the first two that are mentioned. Then there's thought, belief, freedom of assembly, freedom of association, these other freedoms. And then the Charter moves on, talks about rights. Right to life, liberty, security of the person, Section 7, equality rights, and Section 15. And so, but it's important to note here that there's also a Section 1 of the Charter And Section 1 of the Charter basically says that all the rights and freedoms that are outlined in the Charter can be limited if it is justifiable or reasonable to do so in a free and democratic society. And so no freedom or no right is absolute, but they all can be restricted. And so therefore, religious freedom does not give you the freedom or the right to do anything that you believe flows from your religion. The criminal code is still in place, and so religious freedom does not allow you to do things that would otherwise be covered by the criminal code, just as one example. So no freedom is absolute, and so normally what happens is cases like this is often there's, freedoms collide with rights. Or the freedom of the indigenous people to enjoy their territory bumps up against, the right of other people, or the freedom of other people to utilize the land. And then what happens is normally once religious freedom is understood to be in play, then there's usually a process of balancing. So what's a reasonable accommodation between the religious freedom claims of one and the interests of other groups, like government, the corporation wants to build a ski resort. And so normally there's this kind of a balancing act that goes on in the court decisions. But the issue in this case is that it never really got to the balancing section part in terms of Section 2A. The government just kind of ignored the religious freedom concern from the outset.
Okay, we have a question from a viewer, Bruce, that's kind of theological in nature. Isn't the entire earth sacred to evangelicals? So getting back to that idea of that sacred space.
Yeah, and some evangelicals will use the word sacred, some wouldn't. We are stewards of the earth. It's created by God. We are to have dominion over it, stewardship over it, to care for it as stewards. And so if by that we would use the word sacred, then yes, it's all sacred. But then usually within that line of reasoning, then no specific part is more sacred than others. It's all sacred. It all needs to be, it's all a trust. We need to be stewards of the whole earth. And so in this case, but the idea that there's certain parts of the earth that are more sacred than others, that's where usually with an evangelical theology, we either refer to all sacred or kind of nothing that's distinctively sacred. And so, yeah, there would the point taken. But again, the argument would be then we need to be stewards and care for the whole earth, not just specific portions of it.
Yeah. Thank you for that question, and just a good time to remind all the viewers that you can send in questions at any time during the webinar, and we really welcome those. So from the EFC's perspective in your process, how do you choose which cases? Presumably you can't participate in them all. How do you choose which ones to intervene in?
Yeah, we certainly, when a case comes to a lower court, particularly the Supreme Court, which deals with religious freedom, we think it's very important to be present if at all possible, because again, what happens is the court, the Supreme Court of Canada is going to be dealing with the issue of religious freedom. It's going to look at different definitions, the scope of how they interpret religious freedom, how they balance religious freedom with other rights and other freedoms under the Charter, and we don't want to be not present. When they're having a substantive conversation about religious freedom, we want to be there to continue to push for a robust and expansive understanding of what religious freedom is, and weigh in on how the governments or how the courts see and balancing these things. Other areas of concern is the sanctity of human life. Cases that deal with the sanctity of human life, we've often engaged before the courts. So there again, issues of, say, euthanasia, assisted suicide. We were involved in the Rodriguez case years ago, and again in the Carter case in BC at the Court of Appeal, and again before the Supreme Court. Issues concerning vulnerable people. So we intervened in the Supreme Court case about pornography and the sexual abuse of women and youth, and how our prostitution laws are designed and maintained. So we look for some of those principles: sanctity of human life, care for the vulnerable, issues of religious freedom, and look for cases that could be precedent-setting, that will fundamentally affect the criminal code and how we as a society choose to live together.
You mentioned that the court is often trying to determine how to balance religious freedoms with other freedoms. Are you seeing, is there any kind of trend in Canada today with that balancing that you are seeing happening in the courts, or is it really case by case?
It is very much case by case. There are, what's happened is there's been a number of cases recently, and this is one of them, which I mentioned earlier, that the often religious freedom cases dealt with an individual. So religious freedom is an individual's religious freedom that's somehow being affected by some type of government or state action. And so the person's claiming their religious freedom over against a state policy, state action. Perhaps someone's pushing for, they want, if they're a Jew or Seventh-day Adventist, they want Saturday off from working, or a Christian Sunday off from working, those kind of things. So it's an individual claim. Increasingly, there's been group claims. So the question is whether Section 2A extends to groups as well as to individuals. And a lot of the cases involve the ability of religious entities to gather together, groups of people to gather together, and to create structures or institutions that will be able to manifest the faith. So we're involved in a case about a Catholic school in Quebec and its ability to continue to teach curriculum about Catholicism, about ethics from a Catholic perspective. Issues of the expression of faith in public venues and public arena. And I think probably underneath a lot of this is the question of the nature of Canada as being a religiously plural society. That there, that there are a variety of different religious expressions in Canada, a variety of various religious groups that are being manifest in Canada, and how do we adjudicate between those? And is the public square, is that a place where all religious people of religious faith are welcome to organize and to develop institutions and to kind of engage in Canada, in the public life of Canada, or is there a trend to try to privatize or minimize or push the expression of religion into the private sphere? The other subtext to that is we're living in a kind of a quote-unquote secular society. And the question is, what does that mean? Does that mean that there should be, the public square should be neutral? There should be no faith expression? Or is the belief that the public square can be neutral with no faith expression, is that actually one of the competing kind of confessions in Canadian life, that you can have a public square devoid of religious expression? And so in some cases, recently the Supreme Court has recognized that the secularist approach to adjudicating religious freedom is actually one of a variety of religious perspectives that are at play. So even in one case recently that we're involved in Saguenay about prayer offered before a city council meeting, in that case an atheist was objecting to the prayer. And for the purpose of that case, the Supreme Court treated the atheist as having religious freedom protections guaranteed under the Charter. So included the atheist amongst the panoply of groups that would have protection in Section 2A. So that's really the kind of the debate in Canada is, what's the nature of our plural society? Do we live in a confessionally plural society? And what's the to what degree are we going to allow the religious groups to have public expression, public engagement, and how do we adjudicate between the competing claims of the various religious groupings?
Well, you are right in the heart of Ottawa, just blocks away from Parliament Hill. So I'd like you to answer that question if you could. Like, are our rights being pushed more into or religious expression being pushed primarily to the private sphere? Like, what do you think will happen in the next 5 years in Canada with this conversation?
Well, I think that's why getting involved in these court cases are so important. I think there are pressures and tendencies to push religious or faith communities kind of out of the public square into the private. On the other hand, you see, and in various areas, you see a kind of a welcoming on engagement of faith communities in the public life of the nation. So, for example, in the tremendous effort of Canada to settle the 25,000 refugees from Syria, faith groups, and particularly church groups, were very, very active in reaching out and wanting to settle Syrian refugees, whether those refugees were Christian or Muslim. And so at one level, you see a great capacity and engagement of faith communities. We're involved in a coalition pushing the government for better access to palliative care. And that coalition involved Jews and Muslims and a whole manner of Christian groups joining together. So there's a tremendous thing called interfaith conversation that takes place on a regular basis in Canada. We're looking to having a conference in Ottawa area next spring. And again, looking at the whole society, the important role that religion plays in society. And so there's I think, and in some ways, there's still a receptivity and an openness to the important role that churches and faith groups can play in the public square. On the other hand, sometimes you get a sense that there's a push to try to privatize or marginalize or push faith expression out of the public square. It's something that a lot of people don't know how to deal with, how to handle well, and so that's what we need to continue to press against. And I think the case that we're talking about is an excellent example of how does a kind of a secular government deal with religious claims that deal with land of Indigenous peoples. It's something we really haven't wrestled with enough in Canada. And it raises a whole nother range of issues about how seriously will those religious freedom claims of First Nations people be taken as we look at how we utilize and land in Canada.
I know you speak to pastors and church leaders from across the country, and I'm wondering, do you get a sense from them of their feeling about religious freedom right now, that they're being maybe marginalized in their communities, or are they appreciate it? Like, I know in our town, we gathered 5 churches together. We sponsored refugee families. And my impression was this really helped our reputation in town. That's not why we did it, but we felt that it was a positive message we were sharing. So we felt that something was actually restored there. And I'm wondering what you're hearing from people sort of on the front line of ministry in Canada.
Yeah, it's a dual message. The one is gratitude for the freedom we do have in Canada when we compare to other parts of the world where doing what we're doing right now would be illegal. Where we're having, be able to form a church, hold services, have educational institutions that are, faith-based. Even in Canada, having government sponsorship and support for faith-based organizations that care for vulnerable persons in poverty or in other areas of vulnerability. And so on one level, we're appreciative of the freedoms we have, which again means that we need to be good stewards of those freedoms. On the other hand, there is increasing concern. For example, there's a case we're getting involved in along with the Catholic bishops in Ontario involving a policy of the College of Physicians and Surgeons of Ontario, which is going to compel all doctors, regardless of their conscience or religious belief, can compel them all to provide at least effective referrals, if not participate themselves in activities such as providing abortions or physician-assisted suicide or the euthanasia. And so they're having to go to court to defend their conscience rights to say no, to say, as a person of faith, the doctors are Catholic and Evangelical. As a doctor, I cannot kill someone. It's contrary to my faith. And I should not be compelled to choose between my job or my compliance with something that I think is completely unjust and immoral. And so it's cases like that where we're needing to go to court to defend the ability of doctors, in this case, to be able to exercise their conscience and to be integral in terms of their faith and yet still provide good services as doctors.
Let me take this opportunity to give a little plug to the November-December issue of Faith Today magazine, where we interviewed Larry Worthen, who's head of the Christian Medical and Dental Society in Canada, and they're really working with the EFC on that case. And one of the questions I asked Larry was what exactly active referral meant and what the problem with that was, and it was very helpful. So at the end of this webinar, I'll mention a way that people can subscribe to Faith Today for half price today and see that interview. That was very helpful. A question from a viewer: should pastors be preaching about religious freedom, or does that make us too partisan and threaten our charitable status in Canada? So how bold can ministers be in talking about some of these issues?
They can be very bold. The restrictions in terms of Revenue Canada deal with partisan activities, so that religious organizations cannot devote any resources to promoting one party over another or one candidate over another. But in terms of the issues, in terms of things like assisted suicide, euthanasia, in terms of the importance of the church mobilizing to care for vulnerable persons, palliative care, refugee settlement, in terms of championing religious freedom, I think that it's vital that churches engage in this. This is part of how we express our faith. This is how we manifest our faith as Christians, in caring for others and in speaking the truth in love. And by that, I don't mean we should be pushing the envelope and trying to see what we can get away with. I think it's inappropriate according to Scripture. But I think in terms of talking about what religious freedom means and how our faith is not all just a personal faith, but a collective or communal expression of that faith, the importance of churches as religious communities that covenant together in belief, but also in collaborative worship and practice in terms of loving our neighbor as ourselves. I think we need to explore and examine that and realize the degrees of freedom we enjoy right now, and to continue to make sure we are engaged well in caring for others.
We have another question. Have the Truth and Reconciliation Commission, did their report and their calls to action play a part in the EFC's decision to intervene in this particular case?
It certainly was a factor. I think it's how Canada responds to Indigenous peoples across Canada in terms of issues of land claims is certainly it's been with us for generations, literally. And the TRC recommendations certainly call on Canada to be much more, in a sense, diligent in responding to these issues. But it's interesting that this case actually originated long before the Truth and Reconciliation Commission was even conceived. And this is a case that's been percolating for many, many years. And so I think it'd be fair to say, even apart from the TRC and its call to actions, this is a critical case, it's an important case, and something which will set precedents for how we understand religious freedom and how governments respond to religious freedom claims in Canada.
Let me shift gears a little bit. This is another participant's question about competing beliefs. So, for example, the sex ed curriculum in Ontario that's been controversial, and it's been mentioned that it's considered hateful to remove kids from the class because it's against their beliefs. So how does that play into it when we're talking about parents and schools and religious freedom? Is that something you're watching and can comment on?
Very, very much so. Actually, the courts in Canada have affirmed, and the UN Declaration has affirmed as well, that that parents have the prior right to determine the education of their children, and so there should be freedom for parents if they're concerned about the curriculum is going to be taught, if it's going to violate their religious beliefs or contradict their religious beliefs. They need to look ways to respond. I mean, we encourage parents to talk to the teachers to see if there's an alternative ways of approaching the material. There are some groups in Ontario who develop alternative curriculums that can be brought to the principal or the teacher. But again, I don't think it's all hateful to withdraw your child. I think it's, again, a question of how we live out our faith in a plural society, realizing that there's different belief systems, there are different attitudes towards sex or sexual morality, and we need to figure out ways to accommodate those differences. My concern actually would go back to the public system, say if the public system is going to be truly public, it needs to figure out ways to achieve its curricular goals in terms of what kids should understand and know about, but do so in such a way that actually recognizes the religious diversity of the students that are in the school. And I think they need to do a better job at working with parents to find out ways to achieve those agreed upon ends. That was part of the situation in the Loyola case I mentioned earlier in Montreal, that the government had changed the curriculum. And the question is whether the Catholic school could continue to teach, especially in a religious and ethics program, could teach the religion from a Catholic perspective and ethics from a Catholic perspective, or whether they have to become completely secular. I think there's also ways that there's ways to talk with the principal, with the teachers, and find out ways to educate kids about things they need to be aware of in terms of sexual education, but do so in a way that's compatible with religious concerns and convictions of the students and the parents of those students in the classroom.
Yeah. Well, thank you. As we start to wind down, can you tell us what the timeline is for this particular case? What's going to happen next? When will we hear the outcome?
The case will be heard December 1st. Usually Supreme Court hears one case in a day. And so we're expecting and then the Supreme Court takes usually 6+ months to make a decision. And so it'll be, probably next June sometime where we'll hear the outcome. And yeah, so it's something for people to pray about. As we filed our papers, and we'll be putting those on the website. So if some people want to see the factor that we developed, there's information there about how we're proceeding, how we're arguing, as well as the other cases we're involved in. I think people should also encourage them to pray for our lawyers, for the other parties intervening in this case, for the judges who are going to be hearing the case. It's a complex case. It's an important case, and what it boils down to is when we express our religious freedom, there's vehicles or means that we use to express those religious beliefs. For this indigenous nation, it's the land, use of the land. For others, it may be a church, it may be educational enterprise, a school. There are different kind of vehicles or mechanisms, and the question is whether they are protected and seen to be an extension of religious freedom, and they are protected by the Section 2A or not. And so it kind of goes to the core of how we organize ourselves and what is that we require to be able to manifest our faith in a healthy way in Canada.
Thank you, Bruce. And thank you everyone for joining us today. We're happy you were with us. You can find the information that Bruce Clemenger mentioned on the EFC website, which is the efc.ca, and if you add a backslash and the word webinars, you'll find this webinar posted very shortly, and our archive of webinars on a variety of topics. Our next one will be on November 16th at noon, when we're going to be talking about how pornography is a public health issue. We'll be joined by Julia Beasley of the EFC and Glendine Gerard from Defend Dignity, and you can register for that soon. And I mentioned earlier a special deal for Faith Today. You can subscribe to Faith Today magazine for half price for the rest of today at faithtoday.ca/webinars. So we thank you again for joining us, and we hope we'll see you again. Bye.